aspects which perhaps in terms of the work that's been done already in the Legal Services Bill and Act in England and Wales?
Well, firstly, we have to say that when we think about consumers, businesses or small businesses will also be, included in our definition of consumers. But as regards the question about where is, the demand, well, going back to an example perhaps in sort of, rural areas where perhaps there is just a sole practitioner and there may be separate other professional firms, there may be that some of them find it easier to exist together and would prefer to form partnerships, which would mean that they could keep going and offer those services to those consumers, whereas the viability of a sole practitioner may not be viable.
That's about the viability of these two individual businesses coming together to make a more efficient business.
Range of services.
So effectively those services would remain in place as opposed to being lost to smaller communities. But I can see that argument. Yeah. I'm still, I'm still struggling slightly to understand what the advantage is if I wanted legal services today, I would go to see a lawyer. If I wanted accountancy services next year, I would go and see an accountant. And I can't see. I'm trying to understand the difference between what currently exists and what may exist in the future.
The point I'm trying to make is that there might be firms out there who do not have sufficient clients to keep themselves going on their own, but if they banded together with others, they would make their businesses more viable and they could continue to exist. And they may also, with these proposals, bring in non-professionals, such as IT experts, who could innovate their businesses.
I think that's a slightly separate point, and I accept that point. But I think there's a wider issue about the individual benefit and what difference it would make to individual consumers. But I think we'll explore that as we go on.
That can be explored. We'll turn out Nigel Doyle and Bill Butler.
Since the subject has come up, Ms. Aspinall, can I just ask you, what is to stop? All the answers you've given so far have been, it may be the case that, and I understand that because it's often the economics of the world of economics. What's to stop the lawyer and the accountant who are in the high street and want to join together, quite literally putting themselves under the same roof, sharing their secretary, hiring in someone who knows how to do computing? Why, from doing that under the current models, why on earth do they need a new business model called a partnership or some other limited liability company to do that? They can do it anyway as sole traders and simply work with each other, can they not?
They can, but it's not giving the opportunity to offer different models with different expertise. You can't get somebody who's an IT expert, for instance, moving in, helping to own a business and therefore having a direct stake in it and moving it forward, bringing that expertise and that modernisation behind them, which maybe this area sometimes lacks, quite frankly. And for instance, there could be a surveyor partners, legal services, a lawyer, and perhaps offers that as part of the business. At the moment, we know that some of the banks we believe are charging fees for surveys to be done on the home reports, for instance. So maybe that's a way for the surveyor who's partnering the lawyer to say, we'll cut the price of that, we'll offer that right now for less money as part of this one-stop shop service. That's just a possible example.
Forgive me, I take the economics of what you've just said, but what's to stop them from doing that at the moment as two people who choose to cooperate? Why do they have to be in partnership to do that?
The trouble is they're not doing it just now. It kind of needs that opening up of the door to let people start to think about what services they could offer together. Because it's not been done before, they're not offering the services. So it almost needs that door to be pushed open so that people can say, do you know, we could actually do things in a different way. Why don't we have a go at this,
Forgive me, I can open the door by telling them that they can do it at the moment as sole traders working together. Why do we have to change the legal structure to tell them the door's already open?
I suppose just because they're not doing it, really. And the chances for people to own a business across the professions makes that innovation far more likely, really. It's economies of innovation as well and management expertise coming from outside the industry that I think will be beneficial for legal services in Scotland. We'll see things done perhaps in a more consumer-friendly way in some cases where people want that to happen. And our information is that people really do want legal services to be more user-friendly, a bit more modern.
Talking of opening doors, I'll revert to Bill Butler.
Thanks very much, Convener. One aspect of the concept of outside ownership that I didn't touch on, but and that was remiss of me, is a fear that some people have that if things are changed in the way proposed, how will consumers be protected from undesirable third parties taking over law firms?
Well, the ownership of law firms and law practices with other professionals must be fit for purpose. So it's really, ensuring that there is robust regulation. And I might just add that there's perhaps at the moment, however many rules you have in place, that there could be undesirables currently working in law practices. No, I don't think I'd be able to.
They're unlikely, but on you go.
But there is a model at the moment in New South Wales which has allowed external ownership. We're not aware of any major problems arising in Australia. Obviously, external ownership is also envisaged in England and Wales at I think from 2011. So I think it's really a question of robust regulation.
Ms. Clarke?
Well, exactly that. There's a fit-to-own test. That there are... Well, yes, and I think that is a protection for consumers along with all the other measures that are being suggested.
Do you think it's robust enough, this fitness for involvement test?
I think so. We've no evidence that it's not. As far as we're concerned, it does appear to be, yes.
Do you have any evidence that it is?
It's always the difficulty with things that haven't been implemented yet. But
yes, exactly. That was the previous answer.
Yes.
Ms. Brand, do you want to have a go at this?
I think that in terms of the fitness to own, as Sue said, there is some experience, at least elsewhere in the world, and they have made it work and expanded it across the rest of Australia to the other states. So that's one piece of experience, that outside ownership is not necessarily bringing the kinds of hazards that have been suggested may be the case.
You cite New South Wales and Australia. Are there any instances of where there have been problems in New South Wales or Australia? Or has it worked absolutely perfectly?
I think that the fact is they have adopted a similar approach of having a rigorous set of conditions around those who would be enabled to own firms. They have had the kind of monitoring and so on that is envisaged in these provisions, and they have not, as far as we're aware, encountered problems. So that's just one small, you may regard it as slightly peripheral set of evidence, but it's one that's there. But the key is surely that you have those transparent conditions up front so that anyone who proposes to own a firm with legal services as part of the provision is absolutely clear about the kind of hurdle that they have to pass, and that it is clear to the consumers and so on of the kind of check that has been made on those owners, and that there is the continued monitoring so that should that owner at some future point fail to reach that standard, there is the provision for dealing with that situation. And given those provisions, we're comfortable that it can be made to work safely and in the interest of consumers.
Again, I'm grateful for your, I feel like, explication of the theory. Thank you very much.
Right, we must move on, having examined what was a very important aspect of the evidence that we would expect from this panel. Can I suggest, if we are going to get through what we want to get through, perhaps one answer from the OFT, unless there's a specific need that you feel that one of you could augment that evidence. We'll now go on to the regulatory approach with Cathy Craigie.
Okay, thank you, Convener. I'll be concise and as quick as I possibly can. Can I just throw out to the panel to see what evidence is there that the existing regulatory approach is not working, and that a fully independent regulatory body separating representatives and regulatory functions is needed for the legal service market in Scotland?
As regards sort of, the actual evidence, I think the position is that it's really a question of perception. if you are trying